SJC-12533, Commonwealth versus Aldo Dunphe.
Ms. O'Brien, good afternoon.
Good afternoon, Your Honors. May it please the Court, Leslie O'Brien for Mr. Dunphe. I'd like to begin by addressing Mr. Dunphe's argument that the evidence was insufficient, that the Commonwealth failed to disprove or failed to prove that he was criminally responsible at the time of the homicide. That is actually overlaps with the second argument regarding the error in the jury instructions.
Counsel, before you go make your argument, which I want to hear, I'm just curious whether the whole thing, in a broader way, is a reflection of a problem in our statutory structure with regard to mental illness.
I have to confess that I haven't given, maybe I haven't given enough thought to that. I'm not sure.
Okay. I'm just thinking about it.
I'll begin by saying...
Go ahead with your regular argument.
Yeah, thank you, Your Honor. Aldo Dunphe clearly needed help with his marijuana addiction, and his family wanted him to get that help. So on November 1st of 2013, they brought him to UMass Medical Center to get that help, and he had agreed that he would go into rehab. But when he got there and spoke to the medical personnel, he was admitted not to the rehab, but to 8 East, which is the psychiatric unit. And the notation at that time, the medical records are contained in the appendix to my brief. And the notation at that time regarding his condition was psychosis NOS, in other words, not otherwise specified, PTSD, and cannabis dependence. Then on November 5th, on Mr. Dunphe's 4th day, or actually 5th day in the psychiatric unit, he entered the room of a fellow patient by the name of Ratna Bhattari, and Mr. Dunphe, who had no history of violence, killed Mr. Bhattari in a very brutal manner. Mr. Bhattari was an innocent man, and no doubt was there for help with his own suffering. I'm asking the court in particular for attention to the medical records concerning the day before and the day of the homicide. And those are at pages 192 to 194 of the appendix. On the day before, the doctor's note reads, this is on the 4th, that Mr. Dunphe's condition was psychotic disorder now, D/O, not otherwise specified, rule out schizophrenia, rule out drug-induced psychosis. On the next day...
I'm sorry, meaning that that those were possible diagnoses which had to be examined, or that he had ruled them out?
Those were the possible diagnoses that were being looked at that time. The next day, the notation was almost identical, except that it said, rule out schizophrenia versus substance-induced psychosis. So that's what the doctors were working on, ruling out or differentiating between those possible diagnoses. But they had determined that he had some sort of psychotic disorder by that point, by the 4th day. And I emphasize that actually for 2 reasons. First, it's to demonstrate that the diagnosis of schizophrenia, and this was the diagnosis that 3 mental health professionals testified to at trial. I'm referring only to the 3 mental health professionals who are employees of the Commonwealth of Massachusetts. Those 3 mental health professionals, plus Dr. Daignault, who was the defendant's expert, all settled on the diagnosis of schizophrenia. And I'm pointing to the medical records to show, if there possibly could be any doubt, that this was not a diagnosis that was arrived at after the fact to excuse a murder or to get away with murder.
Medical records
It was
indicate
already.
the medical records indicate that it's already within the differential diagnosis.
It was already under consideration, yes, by the doctors that this was a possible diagnosis. And sure enough, afterward, the doctors who examined him came to that conclusion.
Now, there is, I gather, medical evidence, in this case may be the poster child for it, that for individuals who have a predisposition to schizophrenia, the chronic use of marijuana may cause that predisposition to become a reality. Was that the testimony of any? I mean, I think Dr. Daniel testified to that, correct?
He did testify to that, Your Honor, and I think it's that testimony was particularly interesting. I think that's not something. The fact that the connection between use of marijuana and the possible emergence of schizophrenia, I think that's something that very few people are aware of. And I think Dr. Dagnall's testimony was very interesting and is something that really should be more widely known given the general attitudes about marijuana and its supposed harmlessness.
Now, is it your argument that the judge's instructions, if the jury believed that, would have said, well, since this was caused by marijuana or triggered by marijuana, that we cannot consider it to be a mental disorder?
Well, yes, exactly. That was what I was coming to, and the second reason I was asking the jurors, the court rather, to consider these medical records, because the second possible diagnosis of substance-induced psychosis ties in with really an error, not just that error in the judge's instruction, but I'd suggest an error that by the end of the trial had really permeated the case. And that was the error, specifically the error that if Mr. Dunphe had developed schizophrenia or some other mental disorder, psychiatric disorder, because of his marijuana habit, that would not qualify under McCool. And of course, that's not the law. The court decided in Brennan, Commonwealth versus Brennan, and Commonwealth versus Heard, that if someone has a drug habit or drug addiction, if as a result of that they develop a separate, distinct disease, then that does qualify as a mental disease or under McCool.
Well, now, don't we have a causation issue in terms of what causes what, in terms of the case law about voluntary intoxication or voluntary taking of drugs, where a defendant, generally it has been, if a defendant voluntarily is intoxicated or under the influence of drugs, they can't use that as a defense. But here, it's a question of whether the schizophrenia is waiting to emerge as a result of being provoked by the marijuana versus the marijuana causing the schizophrenia. And then all that folds back into whether a defendant knew or should have known he had that likely reaction to the marijuana.
Well, I don't know that there certainly wasn't any evidence that Mr. Dunphe should have known that certainly not by going into a hospital, by trying to get help with his marijuana addiction, that was going to cause this psychotic break. There was no evidence that he was. This is nothing like the DiPadova case, where you have an individual who knows that by taking cocaine that's going to make him violent, and he takes the cocaine, and sure enough, it makes him violent, and he commits a horrible, violent crime. Mr. Dunphe, in contrast, first, there was no evidence of voluntary intoxication. That's what I keep coming back to. There's no case in which this court has found that that the rule regarding voluntary intoxication applies even after the intoxicating effects of the drugs have worn off. The law is in fact the opposite, that if there's a medical disease, a separate disease that develops after the intoxicating effects of drugs have resolved, and it's a recognized type of disease, and it lasts for a period of time. And by the way, according to his clinician, Mr. Dunphe was still being treated for schizophrenia at the time of his trial. Now that's 2.5 years after the homicide. So this was what some jurisdictions call a settled conviction. And there are no cases where the court has applied has sort of applied this causation rationale to the voluntary intoxication cases.
That's step two, though.
This would be a first case to do that, where there was no evidence of voluntary intoxication, none.
But before you even get there, your first position, first of all, obviously you're saying that we've got a mental disease, a defect. But your position first on the voluntary intoxication is that the defendant doesn't know about the relationship between the schizophrenia and the marijuana habit.
Yes,
And
yes,
then-
I'm saying
and
no
then-
one would
and-
know that.
Right, and even if he did, that if he had this habit, but he was withdrawing and he wasn't taught under the influence at that particular time, then the instruction was wrong.
Yes, the instruction was clearly wrong. The instruction was clearly wrong because there was no voluntary intoxication at the time of the crime. It's also, and there's no parallel between cases like DiPadova, where someone, as I've said, takes cocaine knowing it's going to make him violent, and somebody who's trying to deal with an addiction in exactly the way that we hope that somebody might deal with an addiction, by getting medical help. That's what he was doing.
But there is testimony that the defendant knew that marijuana made him paranoid and hallucinate. So
Yeah.
arguably, while he's in getting treatment, he knows he's prone to these hallucinations and paranoid. I guess it doesn't do you much good when you're in it, but
Yes. He knows that he's prone to delusions and hallucinations when he's smoking marijuana. He certainly has no way of knowing, and I don't think it's true. I think Dr. Sella was not credible. He certainly has no way of knowing that there's going to be this theory by Dr. Sella that by trying to withdraw, by trying to get help, by doing the right thing, that he's going to have that his psychosis is actually going to become worse at that point in time. I don't know. I mean, there's really no evidence that withdrawal alone caused this to happen. And even Dr. Sala's testimony was that it was a combination of drug-induced psychosis and withdrawal. Nobody said it was withdrawal alone that caused the psychotic break here. So I think it would be a different question. It would be a question that the court would have to grapple with in a different case. I wasn't able to find anything similar where somebody suffered a psychotic break as a result of trying to withdraw. But I would imagine that it would enter into the court's analysis that this isn't the type of blameworthiness of somebody doing what he knows is going to cause a psychotic break. He's trying to do the right thing. He's trying to get help.
The most apparent comparable example would be delirium tremens, which comes from the withdrawal of alcohol and is described at length in the Rosario opinion as including auditory hallucinations and confusion and behavioral disturbances. Do we have any cases in which the person commits a crime during the course of delirium tremens, which involves the withdrawal from alcohol intoxication?
I could not find any. I couldn't find any cases where there were crimes committed during withdrawal. But I've thought about it quite a bit, and I think that the court would have to be taking into consideration what's going on during this withdrawal. Is somebody withdrawing and doing desperate things to get more drugs? Certainly that type of withdrawal couldn't be an excuse, that's not something that the court would be positively disposed to. But if you had somebody who went into delirium tremens in a hospital while he's supposed to be being supervised and taken care of and perhaps protected from himself, that would be, I imagine the court would view that quite differently and not see that as sacrificing a defense of lack of criminal responsibility.
Did Dr. Silna concede that the defendant killed somebody who he believed to be his birth father?
I can't recall if he actually conceded that. The prosecutor certainly conceded it. The prosecutor conceded in his closing argument. He stated that Mr. Dunphe believed that Mr. Batari was his father, that Mr. Dunphe believed that Mr. Batari was going to harm him. But the prosecutor went on to say, pretty much consistently with this error throughout the trial, that he cautioned the jurors that they shouldn't feel any sympathy for Mr. Dunphe because he had brought this on himself. He brought his problems on himself by his daily use of marijuana. Even defense counsel, even though his own expert had testified that marijuana can be closely associated with schizophrenia, defense counsel attempted to persuade the jurors, he felt he had to persuade the jurors that it wasn't the use of marijuana that triggered the psychotic episodes. Really unnecessary, but it was just something, I'm just demonstrating that this had kind of permeated the trial. It seemed as if all of the players, the judge, the prosecutor, the defense attorney, kind of all bought into this. And since they all bought into that idea, there can't be much doubt that the jurors did it as well, that would have been their understanding, that if this was brought on by the use, if schizophrenia was brought on by the use of marijuana, then Mr. Dunphe forfeited his defense.
What about the points that the defendant waited till the victim was alone in his room, closed the door, attempted to wash the blood off his hands and clothes, taking measures? I mean, that tends to point to the fact that he actually really knew what he was doing.
Well, there was certainly evidence as far as his going in. It was actually his account that he went into the room after the nurse had left. He gave a very different account to the state police, but be that as it may, even if he waited for the nurse to leave, to the extent that he was capable of knowing anything, he knew that the nurse didn't want him to be in that room. Knowing what the nurse thought was wrong or knowing what the nurse didn't want is not the equivalent of knowing that something is wrong or immoral.
All right, but what about the extent to which he went in order to effectuate his goal? I mean, he really made sure he accomplished a task here, and then afterwards he cleaned himself up?
Well, I can't say that he didn't certainly focus on his goal in the belief that he was in danger. But his efforts to clean up, again, this is more evidence of how just fractured he was mentally. Instead of leaving the room, to the extent that he was capable of knowing anything, he knew that there were nurses in and out. He knew that there were people doing checks. He knew that the nurse was coming in and out, ushering him out of the room. But instead of leaving the room, he says he stayed there, took a shower, put his bloody clothes back on himself. Instead of leaving and trying to get back to his own room, he stayed there where the victim was and performed these actions that are just bizarre. putting the bloody clothes back on himself. And I should say that the idea that he washed his clothes, I'm not sure exactly where that came from, but there were at least 3 witnesses who testified that he did have blood on his clothes. He did say that he took a shower, but then put the same bloody clothes back on. So if those can be construed as efforts to avoid detection, they're certainly bizarre and consistent with his being in a very fractured state of mind mentally.
All right, thank you.
Thank you, Your Honors.
Ms. Offring.
Good afternoon. May it please the court, Susan Oftring on behalf of the Commonwealth. The Commonwealth asks that this court affirm the convictions. This is a case in which Dr. Soleil testified that the defendant did not suffer from a mental disease or defect, that he had the substantial capacity to appreciate the wrongfulness of his actions and to conform his conduct to the law. In addition to Dr. Soleil's testimony, excuse me, the Commonwealth submitted other evidence in the form of the defendant's own statements to the police immediately after the crime, together with the medical records that indicate that this is someone who knew the effects of a long-term, prolonged, daily consumption of marijuana that he admittedly, knowingly, voluntarily consumed, even realizing and recognizing that he was suffering from intoxicating effects of that drug, including paranoia, delusions, and hallucinations. And the statement to the police, which I think is pretty telling, is whenever I smoke pot, it sort of sets off other drugs that I've done before. I've tried acid, mushrooms, cocaine, and some prescription pills, and that's at A43. He admits that when he does not use drugs, I do very well. He even acknowledges that it's stupid that I ever started smoking again because it's something I can definitely abstain from. It's not like something I need to function correctly. The trooper asked him, so no mental issues except when you're on these drugs? And he said, yeah, for the most part. Sometimes I could get pretty upset and angry regardless of whether I was doing drugs or not. Clearly, he's been using drugs, I think the testimony was, since he was 17 years old. He was 23 years old at the time of the crime. Dr. Slade testified, and I think it was undisputed at trial, that when he went into the hospital, the last day he was at home was October 31st, and he consumed his daily consumption of marijuana then. His family says he was acting strange. He was experiencing some delusions and hallucinations, mostly in regard to his relationship with his wife. When he's in the hospital, according to Dr. Soleil, he's still suffering from this voluntary consumption of drugs. It's still in his system.
But your argument is that what he suffered from was having stopped using the drugs, that it was the withdrawal from the use of drugs.
Dr. Soleil's testimony, it was a combination. So it's the substance-induced psychosis that he's experiencing these delusions and hallucinations. That's on day 1, 2, and 3. Starting into day 4, he's now going into, still with the drug coming in his system, but yet coming out of the system in the form of a withdrawal, experiencing other symptoms of anger, aggression, and restlessness. It first is demonstrated when he has a visit with his wife, and he calls her all sorts of names, and I think the word was he was hostile towards her. And then on day 5, as Dr. Soleil says, it's now kind of accumulated between these substance-induced hallucinations and delusions with the cannabis withdrawal disorder leading to anger and aggression, and that's when he kills the victim.
So is there any dispute that he believed the person he was killing was his birth father?
I don't think there was much of a dispute. I don't know if we agreed, but I think there was, the defendant did say that he thought that the man was threatening him, but the staff around him never witnessed that. So I don't think the Commonwealth really disputed it, but as Justice Cipher pointed out, and Dr. Soleil found significant, and even to the extent the defense doctor agreed that what the defendant did, despite that delusion as to who the victim was and whether there was a relationship, on that day, he was goal-oriented, directed, purposeful, knew what he was doing. There was testimony from more than one of the staff that they were doing every 15-minute checks on the patients in the psychiatric ward. They would leave the patient doors open so they could see what was going on. At some point,
Now, he was on a one-to-one observation at one point, wasn't he?
I think it was twice.
Twice, but they took it off.
Right.
Is there anything in the record as to why they took it off?
I didn't see anything in the record. There was multiple reports that he had been wandering. I think maybe he tried to escape, but wandering into other person's room, including the victim. And you're right, he was on a one-on-one. I want to say November 3, may have been the last time. His roommate was on a one-on-one and had one of the witnesses we had testify was sitting there in the threshold the morning of the crime, saw the defendant. The defendant's own words to the police officer immediately after, I think it was the UMass officer, was that he waited for the nurse to come, knowing she's giving lunch, knowing she's leaving, and presumably, this isn't in the record, but I think one can infer, he knew he had 15 minutes before the next check, went down to the victim's room, closed the door, and that was testimony from the doctor that said when he looked in, he saw him, asked him what he was doing there, and told him to leave. This is not your room. The defendant made direct eye contact. You're right, it's not, and he walked back to his room. That same doctor testified that...
Can you find any case anywhere in which a court has found somebody criminally responsible when he killed somebody under the hallucinatory belief that he was somebody else, whether he be his father or Hitler or a Martian?
Well, I think there are plenty of cases where the defendant was convicted of first-degree murder, and it was affirmed by this court, where he killed someone in a substance-induced delusional state. I think...
Try my question, where somebody kills somebody believing he's his birth father, or believing he's Adolf Hitler, or believing he's somebody he's not, or believing he's a Martian sent to conquer.
The only case I can think of is someone thought there was bugs on someone, and they beat the person thinking they were bugs. So it was a delusion that wasn't there, led to the killing. But in terms of exactly that scenario, I can't think of one.
So under your theory, let's go to the delirium tremens idea. If somebody was an alcoholic and was suffering hallucinations arising from the withdrawal from alcohol and killed somebody in the hospital as he was being treated for the alcohol and then for the DTs, you would say he's not entitled to a criminal responsibility defense because it was all caused by the voluntary consumption of alcohol.
Well, the case law in Massachusetts, DePova says it. It's the source or the cause of the lack of substantial capacity to conform your conduct to the law. And if that source is voluntary consumption of alcohol or drugs, intoxication, even alcoholism or drug addiction, do not qualify as a mental disease or defect under the McCool Foundation.
Was that a yes? Yes, that person would not be entitled to a criminal responsibility defense?
I would say would not. If a doctor is not testifying for the defense or for the Commonwealth that disease qualifies as a mental disease or defect, prong one, then the answer would be
And if the evidence was undisputed that the person was suffering from schizophrenia, which was triggered by the substantial use of marijuana, you would also say that that person's not entitled to a criminal responsibility defense because the schizophrenia was triggered by the voluntary use of marijuana.
Well, I think that would again be for the jury to decide what is the cause, and that's the jury.
Let's assume it's undisputed that the trigger for the schizophrenia was the voluntary and substantial use of marijuana.
And I think according to our case law is, did the defendant know that his consumption of alcohol or drugs would trigger, and I don't think the case law is he would have to know that he was suffering from schizophrenia. I think the case law is, does he know or should know that his consumption of drugs or alcohol exacerbated or worsened whatever medical condition that is, and either caused the mental disease or defect, or I think it was in Dunphe, they said put him over the edge to render him from having the substantial capacity to now lacking that substantial capacity. So, you know, in a scenario like that if you're saying it's, the jury could have, and the jury in this case could have looked at that and said, well, we think he knew that by continuing to consume these drugs, knowing that it was causing some worsening of whatever mental disease, whatever mental illness or state he was in, that he's criminally responsible.
What the chief had asked you before, and what I'm puzzled on is, this is the cessation of this. He stopped. This is the withdrawal, not the... what counsel had argued was he went into the hospital to get treatment for withdrawals, and now the withdrawal triggers, not the use of.
Well,
the absence of.
I understand that, and it is clearly a dilemma, and it was in front of the jury. The defense argued in his closing, but the evidence was in front of the jury from the Commonwealth's expert. It was still in his system.
I mean, Dr. Solas, it's a cannabis-induced condition. That's at page 170, and that's what you're relying on, right?
A cannabis-induced psychosis disorder with cannabis withdrawal.
And you can't really separate the withdrawal from the disorder, can you?
I don't think you can have withdrawal without intoxication or consumption.
So the withdrawal is just an extension of the intoxication.
Correct. And I think Dr. Lay testified that when it was over, the whole event on November 5th, because the withdrawal symptoms last, I think it peaks at 5 or 7 days, and then he kind of gets through those symptoms of withdrawal, that he kind of came down to, I'm using the word baseline, but almost normal, calm, not aggressive anymore. So it was this unfortunate event that happened at that time, but that's what happened on November 5th and made him responsible, not only looking at what happened on November 5th, but I think you have to look at his actions immediately before the crime, of what he did, and certainly the testimony when the Commonwealth offered, I think, sufficient evidence that kind of casted doubt on the schizophrenia diagnosis existing prior to this event, including the fact that he was able to maintain these relationships and so forth.
Now, I've been a judge for 22 years, and I've never heard of a case or seen a case in which the crime was committed not while the person was intoxicated and under the influence of drugs or alcohol, but purportedly because of the person stopping the use and the withdrawal of it. Are there any cases out there where it's the withdrawal from the prior use of drugs or alcohol which would trigger this type of instruction?
I can't think of a case off the top of my head. My memory, though, and I'll be happy to send a 16L letter if I can find it, because I think I have a binder of as far back as I could go with criminal responsibility cases. But I think it is a factor in at least one, if not two cases, when and I don't even know if it was a Commonwealth expert or defense expert, where they were saying here is why this defendant is or is not criminally responsible. He was suffering from, and I think one of the things was a withdrawal in addition to maybe other disorders. You know, it wasn't really an issue in the case, so I don't think it was fleshed out any further,
But on
but,
cross-examination, the defense attorney asked Dr. Salah, he suffered from a delusional disorder, and he agreed. He said, is that a mental illness? And he said, yes, that's a mental illness.
and
I guess it's the induced part that you
well,
have a
what
problem with?
happened was, that is Dr. Saleh's opinion. The transcript got a little confusing, but that is Dr. Saleh's opinion based on his examination of Mr. Dunphe as of the time he did his examination, I think in 2015. So his testimony was, at the time of the crime, he didn't have a delusional disorder. After the fact, he does agree, he does have a delusional disorder, and that is a major mental illness. Just at the time of the crime, he wasn't suffering from that, and he gave reasons why he could now be suffering from that, which I'll be happy to get into if you
Okay,
want.
thank you.
Unless there's any other questions the Commonwealth asks that this court.
The only thing I will be a request. So with regard to a 16L letter, you're invited to provide a 16L letter identifying any cases where a person has been found criminally responsible, where where they were under hallucination as to the person who they killed. That's the first invitation, and the second invitation is to find any case in which the person was found criminally responsible because the person was found to have acted not from the active use of alcohol, but from the withdrawal of the use of alcohol or drugs.
Okay, you know, maybe in combination with some other diagnosis, but anything I can find, I'll be happy to submit.
Okay, thank you.
Thank you.